I want to talk about House Bill 837 that was passed on March 24th. And if you don't know about it, Governor DeSantis signed a bill into law that has now extinguishes many of the rights of Floridians to have access to the court. There's a whole bunch of little things that go on within this bill, but I'm going to focus on 4 of them. Number 1, the statute of limitations has now changed from 4 years to 2 years. And what does that mean? It means that if you're injured by the negligence of another, before this bill came into a law, you had 4 years to initiate a lawsuit. You might think, well, why do I need 4 years to do it? It's either they're wrong or they're right. There's going to be a lawsuit or there's not going to be a lawsuit. What happens in that time period is someone could be getting medical treatment to see the extent of their damages. 2 years is now shortening that time. Also, it's shortening the amount of time that an individual can negotiate with an insurance company, actually having to file a lawsuit sooner. So the idea that this law is to get rid of lawsuits, it actually does the opposite. It makes it so more lawsuits are going to be filed. Number 2, I think that is important, is the repeal of statute 627-428. This. Prior to this law becoming an action, if you had to sue your own insurance company and you prevailed, then you got your attorney's fees paid for. So why that's important? You pay every month a premium to your insurance company. Your insurance company is there to protect you, to do the right thing. After all, they've been taking your money every month. And what happens if you don't make a payment? They cancel your insurance. Do they give you your money back? Absolutely not. The old law was created so that insurance companies didn't deny claims, drag out claims, because if you had to file a lawsuit and you won, you should at least get your attorney's fees paid for. So this is going to take that away. Now, how that might affect you or affect a Floridian? Let's say you have a small claim, but it's still a valid claim. Let's say you had a property damage claim, even a homeowner's claim, that you had to sue your insurance company because they didn't fix the thing that they were insured to do. And maybe it cost you $5,000. You could file a lawsuit, hire an attorney, and spend $15,000 to get the $5,000 judgment. Well, that doesn't make any sense. Why spend $15,000 to get $5,000? Likewise, if you wanted to hire an attorney on a contingency fee, meaning they get a percentage, an attorney is not going to want to take a third of $5,000 for just about any litigation case. So there it favors the insurance company. Insurance companies are now going to delay and deny claims as much as possible because there's no recourse against them. Third aspect of this case that I think is important are the cap on medical bills and damages. If you're awarded future medical damage and past medical damages at trial. Instead of a doctor having their own billing rate, are going to a computation based on Medicare rates. Now, there is nothing anti-free market than putting a cap on what a doctor can or cannot charge for their services. So those who enacted this bill, who champion small business, who champion free enterprise, have done the exact opposite and actually did the most socialist thing that they could do, tell people what they can charge and tell people that they're not going to be able to get a recovery over a certain amount. Under Statute 768-81 takes away a plaintiff's right to recover if they're 51% at fault. In Florida previously, we were what was called a comparative fault state. And what that means is you can only recover as much as the other person was at fault. Meaning this, if you were in an accident and you were found 10% at fault, you don't get the full amount of your recovery. You get 90% because you were 10% at fault. I think that's a good rule. It says that you can only recover to the extent that you are not at fault. Where this would be important is in a med-mal case where maybe a doctor was only 25% at fault for an injury, but that person who needed the help got hurt by the doctor. He should be able to recover. Under this statute, that wouldn't happen. A lot of accidents happen at a four-way intersection where it's unclear who had the right of way. And sometimes, juries can not necessarily understand exactly who's at fault. And if you were deemed 51% at fault and the other party 49% at fault, and you suffered a major injury and you needed a recovery and you needed the help from their insurance company because they were 49% at fault, you don't get that anymore. That is something that is also going to have a chilling effect on those who need help. So this statute that was enacted is going to have very long-term consequences on Floridians' rights, individual rights, and their access to the court system. If you hear all of this, you think you may have a claim or think no longer you have a claim, still give us a call. Let us evaluate your situation. Review my guides that I have provided to help ascertain whether or not you still have a case, or give us a call if you have any questions about the actual individual parts of these laws. We'd be happy to answer anything we can for you.